Well, this is certainly a very important issue for us to think about as to why there are so many criminals in politics and who are successful in politics. Um, as Mr. Qureshi told you, that there is one proposal that has been made from time to time to deal with this problem, which is that those who have been charge sheeted, or those against whom charges have been framed, those politicians, they should not be allowed to contest, because we can't wait till their conviction, which often happens after many, many years, because they can delay the proceedings. The problem with that suggestion is the following. You see, charge sheet is in the hands of the investigating agency, which we have seen is in the hands of the government, notwithstanding the Supreme Court's orders on police reforms and reforms of the CBI, etc. Despite that, we are seeing that these investigating agencies act largely at the behest of the ruling party, who control them. And it is easy for them to just frame any opposition politician if they want to, falsely frame them. And if they frame them falsely, for example, I'll just give you an example. Let's say that an opposition politician is accused of rape, and they get somebody, a victim, to say that yes, he raped me. Now, obviously, if a police files a charge sheet on the basis of the allegation of that victim, then the court will have no option but to frame charges and hold a trial. So that would mean that till the trial is completed, this politician would be barred from contesting the elections. So therefore, such a provision can lead to a lot of misuse by the ruling party against opposition politicians, who may be wrongly framed, and courts have no option but to frame charges, because at the stage of framing charges, they cannot judge whether the statement or the allegation made by the victim is true or false. And therefore, that was found to be quite dangerous. And therefore, it was felt that the present provision, which says that you are barred only after conviction, if there is no stay of your conviction, that provision should continue. Now, you see, it is true that there is a big problem, because politicians are able to, important, powerful politicians are able to delay their trial for a long time, and thereby prevent their conviction. Very often, in a delayed trial, witnesses also turn hostile. They are able to influence the witnesses, etc. This is primarily a failure of our criminal justice system. Sometimes they are able to delay the investigation itself for a long time. Sometimes even FIRs are not registered, and so on. So, unfortunately, to some extent, this is the result of the non-implementation of the police reforms which were ordered by the Supreme Court. One of the reforms was to separate the investigation wing of the police from the law and order wing, because the basis was that law and order is an executive function, government can be in charge of that. But so far as investigation is concerned, that is part of the criminal administration of justice. And therefore, that need not be under government control, or certainly can be much more insulated from government. And unfortunately, none of that has happened. There was a direction regarding the manner in which DGPs should be appointed, that UPSC should select 3 names, and the government only has an option to select one of those 3, etc. But even that has not happened, and we are seeing that even UPSC's independence has collapsed in recent times. And therefore, Mr. Prakash Singh has made another application for modifying this and having a selection committee for DGPs, just like they have for the CBI director, that is Prime Minister, Leader of Opposition, and the Chief Justice of India. So there is a problem at the level of investigation, there is also a problem at the level of trials. So, and that the reason is that the whole judicial system has collapsed, and trials take interminably long. Sometimes they take 20 years, 25 years, etc. And therefore, for that, we need to reform the criminal justice system. In fact, just yesterday, there was a case in the Supreme Court which was filed by us in 2004 by one lawyer called Mr. V.K. Hori. And the prayer in that petition was that the investigations and the trials of powerful people, and powerful people needed to be defined, and we had attempted a definition of powerful people who are key players in our democracy, should be fast-tracked and should be supervised or overseen by the high courts, etc. That both the investigation as well as the trial of influential people should be fast-tracked and overseen by the high court. This is the suggestion. That case has been still pending. It is adjourned. And of course, one option is then the court asked the Law Commission to examine this proposal, etc. The Law Commission gave a very detailed report. And the Law Commission's report was largely for strengthening the entire administration of justice, of criminal justice, and for speeding up all trials, not just of influential people. Now, judicial reforms is an area which has been pending consideration or really hanging fire for a very, very long time. For many years, for the last 40 years, law commissions have made repeated recommendations that we need to increase the number of judges. Our number of judges is very low. But far from doing that, we have not even succeeded in filling up the vacancies that are of the posts which are already there, of judges both in the lower courts as well as in the high courts. There is roughly 30% vacancy in the lower courts as well as in the high courts on an average across the country. So Law Commission has been saying we need to increase the strength of judges fivefold. Far from fivefold, we are still functioning at only 66 or 70% of the strength of the existing judiciary. Then we made a Gram Nyayalaya Act in 2010 or so. Until now, we have not implemented that Gram Nyayalaya Act. The idea was that at least ordinary petty cases could be disposed of in these Gram Nyayalayas, which would be like courts, but more informal courts, which would be set up at the sub-tehsil level. Today, we have civil courts only at the tehsil level. Unfortunately, even that has not been implemented. So we are seeing across the board failure on the part of the political class and also on the part of the judiciary in implementing judicial reforms which would bring about a quicker administration of justice. And today, after this Justice Yashwant Verma affair, the whole attempt of the government only is to somehow seize control, use this case to seize control of the power of appointments from the judiciary. Of course, there are many problems with the present system, collegium system of selection. There is no transparency, there is a lot of nepotism, etc. But in the collegium, and those problems would remain even if the executive were to get some more control of the judiciary. But at least in the collegium system, somewhat more independent judges are being selected as compared to the system where the government has more say in the manner of appointment of judges. What this government has been doing for the last 10 years is it has been stopping the appointment of independent and competent judges by just sitting on the recommendations of such judges by the collegium and only issuing notifications for the appointment of those judges that this government likes. And and then they are able to sometimes strike a compromise with the collegium and they say, all right, you appoint two of our people, then we will appoint one of the people that you have recommended, etc. So it has become a serious problem. But we need to implement across the board judicial reforms for a quicker decision in all these cases and therefore quicker conviction of the of those who have actually committed crimes and quicker acquittal of those who are innocent. Because even that is important, that if somebody is innocent, he should be quickly acquitted, and that case should not remain hanging for so long. Then we have this phenomenon which Mr. Qureshi also mentioned, that unfortunately, despite the people knowing with this ADR judgment, the criminal records of the candidates come to be known. But yet, criminals are often elected by the people. Why is that happening? That is happening because our whole system of electoral politics and elections has become a game of money. And it has become a game of money because we have first passed the post at two levels. When we select the candidate at the constituency level, the candidate who gets the highest votes becomes the sole representative of the constituency, even if he gets only 25-30% of the vote. If nobody else has got more votes than him, he becomes the sole representative. Then when the government is formed, the party which gets a majority or the coalition which gets a majority becomes the sole government, and the opposition, even if it has 49% of the seats, counts for nothing in running the government. Therefore, when people go to vote, they are not necessarily voting for their best candidate or party if they feel that their best candidate or party has no hope of winning. Now, how do they assess who has some hope of winning or has no hope of winning? That assessment is made on the basis of visibility of the candidates and the parties. And visibility is essentially a function of money. If you have money, you can buy advertisements in newspapers, TV, you can put hoardings, you can have your paid workers going around with your posters, handbills, etc. You can even organize large political rallies on the basis of money. So therefore, only those parties, apart from few exceptions, by and large, only those parties which have a lot of money are able to give an impression to the voters that this party may win, because this party enjoys a lot of visibility. Now, to deal with this problem of spending too much money, a law was brought to put a limit on the spending of candidates. There is a limit of 95 lakhs or 1 crore for Lok Sabha candidates, etc. But firstly, that limit is not enforced because people sometimes spend 50 crores on elections. They spend all the money in cash, and the Election Commission is unable to catch them or unwilling to catch them if they happen to be of the ruling party. Election Commission in the last few years, as we have seen, has become a puppet of the government. And they are unwilling, not wanting to catch people of the ruling party, even if they have spent 50 crores. However, they sometimes may be unable to catch them because they can't really get evidence of this person spending 50 crores because he has spent most of the money in cash, and he declares in his election return that he has only spent 70 lakhs or whatever, 75 lakhs in his election. Now, this could have been controlled if the government had implemented notebandi for at least political parties and the candidates. That means they should have said, when the Prime Minister went for demonetization, he said that, look, I want a cashless society. Now, I can understand that ordinary people can't be cashless, but at least political parties and candidates can be made cashless. You just pass a one-line law, make one amendment to the Representation of People Act, which says it shall be a corrupt practice for a candidate to spend or take any money in cash, period. That will be a corrupt practice for which they will be liable to be disqualified. Now, if you are caught, even in one instance, of spending any money in cash or taking any money in cash, you will be disqualified. If this law had been brought, it would have curbed this thing to a very large extent. Secondly, there is no limit on spending by a political party. Now, if the BJP puts up 500 candidates in the Lok Sabha, at most, all the candidates of the party put together can spend 500 crores. But the BJP in the last 5 years gathered 16,000 crores just by way of electoral bonds as well as other donations. Where is 500 crores and where is 16,000 crores? That means the party can spend 30 times of what the candidate can spend on the elections. There is no limit on the spending by political party, etc. So therefore, we have reduced what Anna Hazare said. We have reduced elections to a game of पैसे से सत्ता और फिर सत्ता से पैसा. After you get elected, you use your power to get more money, and this is what we have come to. Of course, to curb the influence of black money or curb the influence of money in elections, we can implement several other reforms in our electoral system. One of them is proportional representation. In proportional representation, if a party gets 2% vote only nationally, it will still get 2% people elected. That means 11 people will be elected to the Lok Sabha of that party, even if it gets 2% vote. Then I know that even if I am voting for a small party, if that's the party that I like, I am not wasting my vote. Then I will vote for the party that I really like rather than in this first part the post where I will feel that, look, this party is not going to win, I'll be wasting my vote. And therefore, I will vote for the less bad among the two parties who have some chance of winning. This is what is happening. So therefore, proportional representation, then state funding of elections. So there are many candidates or many parties who don't have any money, even not even 1 crore per candidate. So therefore, their candidate cannot even spend 10 lakhs, what to say of 1 crore in the elections. Now, to get over that problem, a proposal was made that you have state funding of elections, which means that every candidate who contests the election, after the election is over, will get, let's say, 50 rupees per vote that he has received. So if he gets 1 lakh vote, he gets 50 lakhs. If he has received 2 lakhs votes, he gets 1 crore. Now, this way, he can take loans from his friends, etc., friends and relatives before the election to contest the election, and then repay them after the elections by getting that money. Those who say that, no, this is too expensive, don't know what they are talking about. 50 rupees per vote only means there are only 60 crore votes which are cast in a general election. It means 3,000 crores, which is peanuts. 3,000 crores for the state to spend by way of state funding of elections is peanuts. And you can put a limit that people will not get more than 1 crore. That means if you've got more than 2 lakh votes, the maximum that you will get is that 1 crore, which means that you won't even spend 3,000 crores, you'll probably spend 1,500 crores. This is an easy thing to implement, but obviously those who are in power, they don't want to do this because they have all the advantage of power. BJP has 30 times as much money as the next political party, 30 times. Now, obviously, BJP will not like to curb if they are in power, they will not like to curb the role of money power in elections, etc. And that is why these political reforms are not being implemented. Therefore, we need to have very, very clear, strong electoral reforms, strong judicial reforms, strong police reforms, if you want to curb this business of preventing criminals from getting elected, etc. Thank you.
Thank you so much for your very wide-ranging comments on. I think you covered almost all the issues which are ailing our system, be it the money power or the muscle power or the system of voting, first past the post, etc. I just want to raise one question to you and to Dr. Qureshi. As per the 170th and the 244th Law Commission report, as also the J.S. Verma Committee report, they had recommended that at the stage of charges frame, a person should be disqualified. What are your views on that?
No, I told you what my views are. They are very clear. That would be dangerous because, see, the court has has no option but to frame charges. The court cannot go into the correctness of the evidence which is produced by a police officer. If the police officer wants to frame an innocent person, then all that he has to do is to put the name of one witness in 161 statement saying that he saw this crime being committed. If it's a rape victim, the rape victim or somebody else who says, no, I saw this person being raped. If it's a murder case, just one witness, 161 statement, maybe a false statement saying that I saw this person murdering. The court in such circumstances will have no option but to frame charges. And therefore, it will be easy for the ruling party who controls the police machinery to disqualify opposition candidates that they fear by just framing them in this way. And that is why this was not eventually accepted.
May I come in on this, General?
Please, boliye.
Yes, sir. Please, sir.
Mr. Prashant Bhushan has very correctly pointed out the risk involved in, the framing of charges, because it is true that charges are framed by the police totally on the basis of the orders of the political masters. So there is no fairness. But judicially, I had conversation with some judges of the Supreme Court at different points in time. One very senior judge of the Supreme Court said that the framing of the charges, the judge can throw out the charges. And he says there are lots of cases which come in appeal that the charges have been framed wrongly and they go into appeal. Therefore, maybe theoretically that is the case, that the framing of charges has to be with the application of some judicial mind. Many other people say that, as Prashantji was saying, that it is almost automatic. Whatever police says, the court says, yes, these are the charges. So, but he knows better.
What I was saying was that it is true that the court has the option of throwing out the charges, but that is if the charges are absurd and not supported by any evidence. Suppose somebody says that, look, this person has committed this murder, he is charged, the charge sheet is filed for murder. And the only evidence that the police produces is that somebody said that, look, I saw him walking past this dead body. Then the court will say, look, this is no evidence to charge him or accuse him for murder, and therefore he is discharged. But if the police is clever enough to say that some eyewitness is saying that I saw him shooting this man or whatever, then charges will have to be framed, because at that stage, the court cannot go into the correctness of the statement of this witness. That's what I was saying.
Yeah.
Mr. Bhushan, thank you very much.
Thank you.